PVL3702, Chapter 3, Number 3.1, Introduction. Chapter 1 introduced the dual basis of contracts in modern South African law. The primary basis is the will theory, which requires actual substantive agreement between the parties for contractual liability to arise. The secondary basis is the reliance theory, which provides that when the parties are not in agreement, contractual liability nevertheless may arise on the basis that the one party led the other party into a reasonable belief that consensus had been reached. Although that seems simple enough, the reliance theory has in fact been applied in several guises as a corrective mechanism in cases of disagreement or dissensus. This chapter concerns potential contracts that lack a substantive consensual basis, or rather, in which there is a material mistake that precludes consensus ad idem between the parties. We examine the ways in which the courts have used reliance-based objective criteria to determine the existence or absence of contractual liability in these situations. The word mistake has a very wide connotation in popular discourse. In the context of the law of contract, it has a more restricted meaning. Generally speaking, to be mistaken is to be under a misconception about something. Mistake in contract, however, refers to the situation where a contracting party acts while under an incorrect impression regarding some or other fact that relates to and affects the contract between the parties. An important distinction is drawn between a mistake that vitiates, destroys actual consent to the contract, and one that does not affect consensus as such, but which nevertheless may render the contract voidable or rescindable. If the parties are aware of their disagreement, they may take steps to remedy the situation or decide not to enter into a contract after all. However, one or both of the parties may be unaware of the lack of agreement because of a misunderstanding of the other party's intention, and it is this situation that is the subject of this chapter. For present purposes, a mistake or error generally may be said to exist where there is a disagreement or dissensus between the parties at the stage of possible conclusion of a contract, and where one or both of the parties is unaware of the disagreement. Number 3.2. Classification of mistake. Mistake in contract can be classified in different ways. Our law has evolved to categorize mistakes using a variety of distinctions and having a variety of consequences for contracting parties. It is important to understand these distinctions and classifications in order to identify the legal consequences correctly. 3.2.1 Unilateral, mutual, and common mistake. Apparently, under the influence of English law, the courts tend to categorize mistakes as being unilateral, mutual, or common. It seems that a unilateral mistake occurs where only one party is mistaken, while the other party is aware of his or her mistake. Mutual mistake refers to the instance where both parties are mistaken about each other's intention and are at cross purposes. In other words, neither is aware of the other's mistake. The distinction between unilateral and mutual mistake is of little practical significance, since in most cases a mutual mistake is present, as the following example illustrates. Suppose that A agrees to purchase B's property. A erroneously mistakes another property for B's property, while in fact B's property is situated further down the road. If B is unaware of A's misapprehension, B mistakenly believes there is consensus and the case is therefore of mutual mistake. But if B is aware of A's mistake, it is a case of unilateral mistake. Both scenarios, however, are cases of dissensus, and the distinction therefore has little importance. Unsurprisingly, the term unilateral mistake is sometimes used to describe both instances. A common mistake is one that is shared by the parties and differs fundamentally from unilateral or mutual mistake, because it does not lead to dissensus. Nonetheless, it results in a contract being void as it rests on a common underlying supposition that is later revealed to be incorrect. Since common error is not a true case of mistake, or rather dissensus, it will be discussed separately. Then there's just a small summary table of the three types of mistake. Okay, 3.2.2, irrelevant and relevant mistake. It is sometimes stated that a mistake does not negate consensus and is therefore an irrelevant mistake if it did not affect the mistaken party's decision to enter into a contract. If the mistaken party would have entered into the contract despite a mistake that causes dissensus, it seems that the mistake may be regarded as irrelevant insofar as the question of agreement is concerned. In Khan versus Naidu, the appellant signed an agreement as surety for the debt of her son, while under the impression, induced by the misrepresentation of her son, that she was consenting to something completely different. Although the appellant's mistake would normally indicate an absence of consent on her part, the court held that she was bound to the suretyship because she would have signed the document even if she had been aware of its true nature. From this, it seems that the mistake must influence a party's decision to conclude a contract in order to be relevant to the question of possible dissensus. 3.2.3 Material and non-material mistake. If we accept that actual agreement is the primary basis of contractual liability in accordance with the will theory, then the first question that arises when determining the existence of a valid contract is whether the parties in fact reached consensus ad idem. On the basis of the will theory, if consensus is reached and provided the other requirements for a valid contract are met, a legally binding contract arises. However, if the parties are not in agreement, then no contract will exist on the basis of the will theory. In such circumstances, unless the contract can stand on the secondary basis of reliance, it will be void ab initio. The distinction between a material, that is, an operative or essential mistake, and a non-material mistake is crucial to the question of consensus. A material mistake is an error that vitiates or negates actual consensus between the parties. To this end, a material mistake must relate to or exclude an element of consensus. Conversely, a non-material mistake does not exclude actual agreement between the parties, because it does not relate to an element of consensus. Consequently, in the case of a non-material mistake, a valid contract will still arise. Although it may be voidable or rescindable if consensus has been obtained in an improper manner by way of misrepresentation, duress, undue influence, or commercial bribery. The distinction between a material and non-material error is vital in determining the appropriate resolution to a situation where a party was mistaken about something when entering into a contract. On the one hand, if the mistake is material, the issue is one of dissensus, or true mistake, and the secondary principles of reliance have to be applied to determine whether a contract based on reliance has arisen, or whether the mistaken party may be exonerated from contractual liability because the potential contract lacks a legal basis. On the other hand, if the mistake is non-material, a consensual contract exists, and there is no need to apply the principle of reliance because the contract already has a legal basis, that is, will theory. It is clear that materiality has a very specific connotation on the context of mistake, and it should not be confused with materiality as applied to other areas of the law of contract. Counterpoint. Confusing aspects to the inducement requirement for a relevant mistake. The Khan versus Naidu approach referred to above requires a mistake, if it is to be relevant, to act as an inducement to contract, in the sense that the mistake must influence a mistaken party's decision to enter into a contract. However, an inducement requirement within the context of material mistake excluding agreement may lead to some confusion because inducement is also an acceptable prerequisite for determining the materiality of an actionable misrepresentation. Consequently, it is suggested that inducement should be confined to not mistake, and that when determining the materiality of a mistake, the appropriate route should be to focus merely on whether the mistake was of a type that vitiates actual consent to the contract or not. Viewed from this perspective, the mistake in Khan versus Naidu may well be regarded as having been material. And there's just a small diagram, figure 3.1. 3.2.3.1 Material mistake. Chapter 1 sets out the elements of consensus, being that the parties must, first, seriously intend to contract, secondly, be of one mind as to the material aspects of the contract, namely the terms of the proposed agreement and the identity of the parties to it, and lastly, be conscious of the fact that their minds have met. If for some reason or other the parties are not in agreement about one or more of these elements, there is a material mistake. It is worth taking a closer look at the elements of consensus and at some examples of material mistake. Serious intention to contract. If a contracting party lacks the intention to be legally bound by an agreement that is animus contrahendi, there can be no consensus. There are various reasons why a party may lack the intention to be bound in law by an agreement. For instance, a party may make a declaration to contract in jest, rixa, or merely intend a social agreement, that is a gentleman's agreement, to arise. In Mondorp Eiendomsagentskap BPK versus Kemp en de Beer, the appellant representative signed a document that the respondent alleged amounted to an undertaking to pay certain monies to the respondent. The appellant denied that the document contained such an undertaking and contested its liability. The majority of the court found that no contract between the parties had come into existence. However, Chief Justice Rumpf clearly stated in his judgment that the appellant's representative did not intend to give an undertaking in terms of which the appellant would become the debtor of the respondent. In other words, the representative did not sign the document with the intention of incurring contractual liability for the appellant. Furthermore, it should be mentioned that parties sometimes outwardly give the impression that they wish to create certain legal consequences, while they actually intend different consequences or no juristic consequences at all. Although not a case of mistake, it should be noted that the law judges such stimulated juristic acts in accordance with the actual intention of the parties and not the simulated contract. Plus valid quod auditor quod simulate concepitor. Forgive my Latin, please. Agreement as to the material aspects of the contract. The parties should be ad idem regarding the consequences they intend to create, namely the persons between whom the obligations are to be created and the content of the obligations, that is, the performances to be rendered. A mistake regarding the parties to a contract will usually be material. If a party inadvertently accepts the offer of one party while it actually intended to accept the offer of a completely different party, the resultant error will be material. Similarly, if an offerer intends to make an offer to a specific person only and the offer is purportedly accepted by the offeree and another party jointly, there cannot be consensus. The most common of operative mistakes are those that relate to the material terms of contracts, and more specifically, the aspect of contractual performance. For example, the parties may be of different minds regarding the subject matter of the contract. In Allen versus 16 Sterling Investments Proprietary Limited, the plaintiff believed that he was purchasing the property pointed out to him by the defendant's agent. However, the deed of sale that he signed referred to another property which the plaintiff did not intend to buy. In other words, the parties were not in agreement as to what was being bought and sold. A further common type of material mistake deals with the situation where a contracting party does not understand the legal consequences of a contractual provision, usually because the mistaken party is unaware of the particular provision in a document that embodies the terms of the contract. So, for instance, if a party is unaware of a contractual term that excludes remedies for misrepresentation by the other party, the resultant mistake will be material. Similarly, where a company director signs a credit application form on behalf of the company but is unaware that the application contains a suretyship clause binding him personally as surety for the debts of the company, the director's mistake will be material. Generally speaking, any mistake regarding a contractual clause that permits a party unilaterally to vary an aspect of performance, such as the date on which performance is to occur, or even entitling a party to release itself from liability altogether in certain circumstances, will be material. In all these examples, the parties are not ad idem as to a material aspect of the proposed contract between them. Consciousness of agreement. An integral element of consensus and the will theory is that the parties must not just have coinciding declarations of intention, but must also be aware of each other's intention for a consensual contract to arise. So, a mistake that precludes conscious agreement between the parties will be material. The parties' declarations of intention are usually expressed in the form of an offer and an acceptance. However, the offeree must be aware of the offer before he can accept it. Likewise, the offerer must be aware of the acceptance for a true meeting of the minds to occur. A leading example of dissensus resulting from a lack of conscious agreement is Bloom versus American Swiss Watch Co. The respondent promised a reward to any person who could provide information leading to the arrest of thieves who had stolen jewelry from it. The appellant provided such information while he was unaware of the promise of reward. Later, the appellant became aware of the offer and proceeded to claim the reward from the respondent. The court found for the respondent, it held that the appellant could not accept an offer until he knew of it. There was therefore no consensus and hence no contract. 3.2.3.2 A non-material mistake. Non-material mistakes, while usually influencing a party's decision to enter into a contract, do not affect the element of consciousness. Notwithstanding a material mistake, if the parties are ad idem as to the material aspects of the proposed contract, a consensual contract comes into being. Typically, a mistake of this nature relates purely to the reason or motive of the mistaken party for entering into an agreement, and hence is usually referred to as an error in motive. In Diedrichs versus Minister of Lands, the defendant extended an offer to the plaintiff to purchase property from the latter. However, the defendant could merely have invoked a clause in an existing lease contract in terms of which the defendant would have repossessed the property at a much cheaper rate. The plaintiff accepted the offer, but subsequently the defendant refused to honor its undertaking, alleging that the offer was made as a result of a clerical error. The plaintiff asked the court to declare the contract valid. The court found that the defendant's mistake related to its motive for making the offer, and did not include mutual assent or consensus between the parties. Consequently, a valid contract existed. It should be stressed that just because the parties have reached consensus and a contract has arisen does not necessarily mean that a mistaken party is without legal recourse. If the mistake in motive was induced by the misrepresentation of the other party, the mistaken party may have a remedy, provided the requirements for the particular form of misrepresentation have been complied with. 3.2.4 Traditional classification of material and non-material mistakes. Historically, mistakes have been categorized according to type, and the materiality of a mistake has been determined on the basis of the type of mistake in question. This does not mean that the one is dealing with a completely different set of mistakes to those previously discussed. It is merely a different way of stating the same principles with reference to prominent instances. There are 4 traditional classifications. First, error in corpore. This is a material mistake concerning the subject matter of the contract, or rather the object of the performance. The most prominent example is where property is purchased and the parties have completely different properties in mind. For instance, in Mareski versus Morkel, the respondent was under the impression that he was purchasing property at Site A because of an advertisement in a newspaper to that effect. The appellant's agent failed to point out to him that the property was in fact situated at Site B. The court found that the respondent's mistake was in corpora, which vitiated his consent to the contract. Secondly, error in negotiation. This is a material mistake relating to the true nature of the contract, the juristic act concerned. An error in negotiation is fairly rare, but Kahn versus Nido may be construed along these lines. There, the appellant was illiterate and signed an agreement as surety for the debt of her son, while under the impression that the document had to do with the transfer of property to her. The appellant was clearly mistaken as to the real nature of the juristic act involved, since such a mistake will have a bearing on the performances involved. It may be regarded as an example of error in corpora. Third, error in persona. This is a usually material mistake regarding the identity of the other party to the contract. For example, in Cook versus Osborne, the defendant believed that he was selling his property to the plaintiff and another party jointly, whereas he was in fact only contracting with the plaintiff as purchaser. The court found that the defendant was mistaken as to the identity of the party or parties with whom he was contracting, and that there was therefore dissensus. However, the courts have complicated matters. At times they have indicated that an error in persona is material only if the identity of a party is of vital importance to the mistaken party. In so doing, they adopted the view of Pothier, which seems to have been in accord with the Roman Dutch law. This approach of the courts has also been linked to the notion that only mistakes that play a material role in the decision of the mistaken party to enter into a contract can be regarded as legally relevant. Okay, then there's a counterpoint. There may be further distinction to be made regarding error in persona. Hubbard convincingly suggests that one should distinguish between an error in respect of the identity of a contracting party, which is always material because the identity of a party is vital for consensus to exist, and cases where there is merely a mistake regarding the name or perhaps some other attribute of a party, in which case the mistake is not material. Error in substantia or error in qualitate. Traditionally, this kind of mistake has not been seen as material in our law. It is a mistake regarding an attribute or characteristic of the subject matter of the contract, object of performance, that is generally not regarded as material. In Trollop versus Jordan, the appellant purchased a farm from the respondent in terms of a deed of sale that correctly reflected the boundaries and extent of the farm. However, the appellant was misled into believing that the farm included more afforested land than it did, because the respondent's agent had pointed out the boundaries of the farm incorrectly. The majority of the court found that the appellant's mistake was not in corpora. The general tenor of the court's approach was that if the parties had the same performance in mind, the mistake could not be in corpora. This decision implies that an error in substantia is not regarded as material in our law. Moreover, such a mistake usually will amount to an error in motive, which is not material or operative. A recent case that has, however, raised a question over the materiality of an error in substantia is Spenmac Proprietary Limited versus Doctrine, where the court clearly was dealing with such a mistake, but contrary to the traditional approach in positive law, it found that the mistake in question was material. The appellant was the owner of a unit, Unit 1, in a sectional title scheme and misrepresented through its representative to the respondent that the unit was one of only two in the scheme, and that the owner of the unit, Unit 1, had a right to veto any subdivision of the other unit, that is, Unit 2. The misrepresentation induced the respondent to enter into an agreement to purchase the unit, that is, Unit 1. It transpired that permission for the subdivision of the other unit, Unit 2, had already, some years before, been granted, and that it had in fact been subdivided into 110 units. The appellant's agent had seemingly forgotten that permission for subdivision had previously been granted and failed to ascertain the actual position. Despite the fact that the matter had been discussed prior to conclusion of the agreement, one of the provisions of the agreement was an acknowledgement by the respondent that it had not been induced by any representation to enter into the agreement, and that it waived any rights it might have acquired as a result of such representation. Ultimately, the actual position came to light, and the respondent applied successfully to the High Court for a declaration that the agreement was void for a fundamental mistake as to the nature of the property. On appeal, the Supreme Court of Appeal unanimously accepted that the misrepresentation of the appellant had been innocent and held that the parties had been mutually mistaken about the true nature of the subject matter of the sale. As a result, the entire contract was void from the outset due to a material and reasonable mistake as to what the mercs was. Nevertheless, a moment's reflection reveals that the mistake in question was not in corpore relating to the identity of the subject matter or the sale, but rather one in qualitate pertaining to an attribute of the mercs. The parties had the same property in mind, Unit 1, in the sectional title scheme, but were under the mistaken impression that the owner of this unit had a right to veto any subdivision of the other unit, Unit 2. This veto right was an attribute or quality that previously had attached to Unit 1, but which subsequently had been relinquished. This makes it rather difficult to determine the actual impact of this case. On the one hand, it could imply the importation of a doctrine of material error in substantia into our law. The exact ambit and application of such a doctrine would have to be further developed. However, the court did not overrule previous authority to the contrary on this point. On the other hand, the court could simply have incorrectly applied the law to the facts. In either case, this decision creates an element of uncertainty that requires clarification. Counterpoint. The traditional classifications are not exhaustive. The traditional list classifying mistake is certainly not exhaustive, and although useful in recognizing specific types of material and non-material mistake, the real focus should be on whether a particular mistake relates to the content of an obligation, an operative mistake, or merely to the motive for incurring such an obligation, a non-operative mistake. The question should always be whether there was consensus, or conversely dissensus, in keeping with such an approach. It might also be prudent to regard all instances of error in persona as material. 3.2.5 Mistake of law and mistake of fact. The distinction between a mistake of law and a mistake of fact crops up sporadically in case law, but has not yet been dealt with decisively by the highest courts. There is therefore uncertainty regarding the possible effect of a mistake of law in a contractual setting. On the other hand, this stems from certain common law texts dealing with an issue outside of contract law that require an error of fact, error facti, before a plaintiff can successfully use an enrichment action, condictio in debiti. That is, if the plaintiff here relies on a mistake of law, error juris, he or she will be unsuccessful. It seems doubtful that this distinction was applied in Roman or Roman Dutch law to the issue of dissensus in contractual disputes. But in Kimberley Share Exchange Co. versus Hampson, the court held that a plea of mistake of law in relation to the entering into of an agreement disclosed no legal ground of defense. On the other hand, there are older cases in which the view was adopted that a party who was mistaken in law had essentially waived a right and that such a waiver was invalid if the party was unaware of the right. However, more recently, in Van Aartsen versus Van Aartsen, the court appropriately held that a mistake of law that relates to motive does not exclude consensus ad idem between the parties. Counterpoint. Whether a mistake is one of fact or law, the key question is whether the mistake only affected the motive for entering into the contract. It is suggested that the correct approach is to determine whether the mistake in question, whether of law or fact, merely relates to motive. If so, it is not a material or operative mistake. If the mistake did not play a role purely in the motive for the contract, then the question arises as to whether the mistake affected consensus. If it did, the mistake is material. The classification of a mistake as being one of law or one of fact should merely be incidental to the main inquiry. And then there is just a small table that sums up basically what we were doing now. Number 3.3. Limitations of the will theory. Unqualified acceptance of the will theory as the basis for contract has the inevitable result that, if it is clear that there is dissensus, contractual liability cannot arise. Even if a contract seems to have come into existence, either party would be able to escape liability by arguing a lack of consensus. On a strict application of the will theory, every material mistake prevents the existence of a contract. However, unwavering application of the will theory would have extremely unfair results in certain circumstances. For example, a party could set up a mistake in advance and then argue lack of agreement should he or she later wish not to be bound. In the case of reservio mentalis, a person deliberately creates the impression that he or she is agreeing to a contract, while tacitly registering the mental reservation that he or she does not really intend to be bound. This tacit reservation excludes actual agreement between the parties, and therefore, on a strict application of the will theory, contractual liability cannot arise. It is clear that the will theory could in this way be used to promote fraud and perjury. A denial of contractual liability in instances where dissensus is not readily apparent to all parties could result in undue hardship for a party who has incurred expense in reasonable reliance on the existence of a contract. It could also greatly affect the reliability of contractual commitments. Consequently, in South African law, as in other legal systems that favor a subjective approach to contract, the will theory is not applied without qualification. 3.4. Reliance-based correctives. In Chapter 1, the various approaches that have been adopted by the courts over the years to the issue of contractual liability are discussed. In brief, the courts have alternated between subjective and objective basis of contract. The subjective approach, as encapsulated within the will theory, has been qualified by the doctrine of Estoppel and its close relatives, the doctrine of quasi-mutual assent, direct reliance theory. The far more controversial declaration theory represents the extreme version of an objective approach and has been corrected by the Justa's error doctrine, which is usually regarded as an indirect application of the reliance theory. It is evident that the point of intersection between the subjective and objective approaches is reliance. More recently, the courts have attempted to reconcile the subjective and objective approaches. Although the case law reflects a mixture of principles, it is now generally recognized that the primary approach to contractual liability in our law is subjective, but that it is qualified by reliance as a secondary theory of liability. The manner in which these various reliance-based correctives or qualifications have been applied within the context of material mistake is discussed below. 3.5. The subjective approach as qualified by Estoppel and quasi-mutual assent. From a contractual viewpoint, the doctrines of Estoppel and quasi-mutual assent have a common heritage, namely the principle formulated by Blackburn in the English case of Smith versus Hughes. I apprehend that if one of the parties intends to make a contract on one set of terms, and the other intends to make a contract on another set of terms, or as it is sometimes expressed, if the parties are not ad idem, there is no contract, unless the circumstances are such to preclude one of the parties from denying that he has agreed to the terms of the other. The rule of law is that stated in Freeman versus Cook. If whatever a man's real intention may be, he so conducts himself that a reasonable man would believe that was assenting to the terms proposed by the other party, and that other party, upon that belief, enters into the contract with him, the man thus conducting himself would be equally bound as if he had intended to agree to the other party's terms. This principle was received into the South African law as an objective corrective mechanism where contractual parties were not in agreement. However, the doctrinal basis for the principle has been the source of contention. On the one hand, there is authority for the notion that the Blackburn dictum is an expression of Estoppel. This is further substantiated by the fact that Freeman versus Cook, on which Blackburn relied, is a leading English case on Estoppel by representation. On the other hand, the balance of authority indicates that this dictum actually deals with the doctrine of quasi-mutual assent or direct reliance theory. The latter seems to be the correct view. In effect, then, Blackburn used Estoppel to create a reliance-based ground for contractual liability in the absence of agreement. Pause for reflection. Both doctrines, Estoppel and quasi-mutual assent, protect reasonable expectations. The doctrine of quasi-mutual assent evolved from Estoppel by representation, but differs from Estoppel in that it gives rise to an actual contract, while Estoppel only maintains the fiction of a contract. It is often said that, to avoid confusion, these two concepts should remain distinct from each other within a contractual context. However, what these doctrines have in common is that both protect reasonable expectations and both can serve as a qualification to the will theory. Furthermore, in many instances, the outcome on an application of either approach will be the same, except that Estoppel only gives rise to a fictional contract, as opposed to a real one. We look more closely at each of these doctrines below. 3.5.1 The Doctrine of Estoppel. The doctrine of Estoppel by representation was introduced into South African law from English law. Generally, in terms of this doctrine, where one party, the Estoppel raiser, has a reasonable belief in a misrepresentation made by the other party, the Estoppel denier, and relies thereon to his or her own detriment, the Estoppel raiser may hold the Estoppel denier to the misrepresentation, in the sense that he or she can prevent the Estoppel denier from lying on the true state of affairs. However, Estoppel will only be upheld if the impression created is maintainable in law. A successful plea of Estoppel has the effect that the misrepresented facts are upheld between the Estoppel raiser and the Estoppel denier as if they were correct. For example, assume that A makes a representation to B, who relies on this representation and alters his position accordingly. Assume B's reliance is also reasonable in the circumstances. A later denies the truth of his misrepresentation in court. If A could assert and prove the true state of affairs, that is, that his representation was false, B would suffer prejudice. Accordingly, on grounds of fairness, A is stopped from leading evidence to contradict his earlier representation, and, in effect, the representation is upheld by the courts as if it were the truth. In Forden versus Leilefeld, the owner of a racehorse hired it out to B and L. To evade jockey club regulations, the agreement between the parties, a lease contract in reality, was simulated to create the impression of a contract of sale. B and L received a false receipt for the fictitious sum of £100 to enable them to act as owners of the horse in their dealings with the Jockey Club. Subsequently, however, they sold the horse to the defendant. The true owner of the horse claimed it from the defendant with the re vindicatio, but the defendant successfully pleaded Estoppel. The owner of the horse had placed B and L in a position to represent themselves to the defendant as the owners of the horse. The court held that, although the false receipt was intended to deceive the Jockey Club, its effect was to enable B and L to represent themselves as owners of the horse to any member of the public. In effect, then, the court upheld the fiction that B and L were the legitimate owners of the horse, as if it were the truth. There is support for Estoppel as a means of qualifying the will theory in instances of dissensus. In Van Rijn Wine and Spirit Co. versus Chandos Bar, the appellant's agent sold liquor and falsely assured one of the partners in the respondent firm that if she paid him cash, the respondent would receive the merchandise at a reduced price. The idea was that the respondent would still be invoiced for the full price but would be entitled to ignore the invoices because they were merely sent out to satisfy other members of a liquor ring that had fixed a standard price. The appellant did not receive the money paid to its agent and was unaware of the representations made to the partner in this regard. The appellant claimed the invoice price from the respondent. Since it was able to prove actual agreement between the parties, the appellant invoked the doctrine of quasi-mutual assent and alleged that it was reasonable in believing that the respondent had assented to the prices in the invoices by failing to challenge them. The court held, with reference to Smith and Hughes versus Hughes, that the principle involved was one of estoppel, but found for the respondent on the basis that the partner had not been unreasonable in believing the appellant's agent, nor would a reasonable man have inferred that she was assenting to the terms of the invoices in the circumstances. In principle, though, the court accepted that estoppel could have succeeded in the circumstances. Pause for reflection. Limitations of estoppel. Although the broad principle seems clear enough, the application of estoppel within the context of material mistake has problematic aspects. For one thing, the elements of estoppel place a fairly heavy burden of proof on the party raising estoppel. This party must not only prove that the other party represented facts that justify a reasonable inference of consensus, but notably must also prove prejudice. Although the mere act of entering into a contract in reliance on another party's representation would seem to constitute prejudice, the appellate division has, by implication, cautioned against the watering down of the requirements for estoppel within this context. Similarly, while textbooks often state that fault, intention or negligence is a general prerequisite for estoppel to succeed in these circumstances, the position is in fact far from certain. A further difficulty is that successful reliance on estoppel merely gives rise to a fictional contract between the parties and the contractual rights may then not be ceded. Protection is thus afforded to the estoppel raiser alone and not to third parties to whom a contractual right may have been transferred. The application of estoppel to the matter of dissensus remains possible, although unlikely because the circumstances that give rise to estoppel should suffice to ground a contract based on quasi-mutual assent or direct reliance theory, which is a contract in the complete sense. 3.5.2 The doctrine of quasi-mutual assent or direct reliance theory. In contrast to estoppel, the doctrine of quasi-mutual assent or direct reliance theory is a basis for an actual rather than a fictitious contract. From a South African perspective, the doctrine argues that for contractual liability to arise in the absence of consensus requires a reasonable belief on the part of one party, the contractual assertor, induced by the other party, the contract denier, that the latter had agreed to the contract in question. Thus, a contractual liability is grounded in reasonable reliance on the appearance of agreement, or rather a reasonable belief in the existence of a consensus that was induced by the other party. Possibly the first incarnation of this approach in the South African law of contract is to be found in Peters and Co. versus Solomon, where the plaintiffs ordered to pay the amount owing by one Berger to the defendant in the belief that it amounted to £345, when in fact it was £490. The defendant accepted the offer but was unaware of the plaintiff's mistake. The trial court found that the defendant was entitled to payment of the full amount. On appeal, the plaintiffs contended that they never intended to make themselves responsible for more than £345. The appellate division upheld the defendant's claim for the full amount. However, more importantly, Chief Justice de Villiers expressed himself in a manner clearly suggestive of a reliance-based contract. If their course of dealing with the defendant was such as reasonably to lead him to believe that they intended to pay him the full amount of his claim, the plaintiff's unexpressed intention to pay the lesser sum cannot avail them. Having asked the defendant to send in his statement and having received that statement without demur before confirming the agreement of December 1908, they must be held to have undertaken to pay the amount appearing according to that statement to be due by Berger. Another early example in which the reliance theory was clearly applied is Hodgson Bros versus South African Railways, wherein the plaintiffs offered in writing to sell a certain lorry to the defendant for £500. The defendant wrote back and indicated that it would be prepared to take over the lorry, provided that certain spare parts for it were included. The plaintiffs accepted these terms. Shortly afterwards, the plaintiff received a telegram informing them that the defendant had omitted in his letter to state the price that it was prepared to pay for the lorry, and that this price was £300. The plaintiffs adopted the stance that the defendant was bound by contract to purchase for £500, while the defendant repudiated any form of contractual liability. In finding for the plaintiffs, the court expressly applied the principle in Smith v. Hughes and held as follows. It may have been unfortunate for defendant, but having induced the erroneous belief in the minds of plaintiffs, they were bound thereby, whatever their actual intention may have been. The elements of the doctrine of quasi-mutual assent or reliance theory may be divided into two constituent parts. The first requirement is that the contract denier must have induced the reliance or belief of the contract asserted that the parties had reached consensus, or that the contract denier had agreed to the contract terms in question. The second element is that the contract asserter's reliance must be reasonable in the circumstances. Where there are circumstances that would have alerted the reasonable person as to the possibility of a mistake or lack of agreement between the parties, and the contract asserter did not act thereon to clarify the situation, the reliance cannot be said to have been reasonable. The decision in Ryden versus Van der Spey and Partners, Weskaap, Incorporated, clearly illustrates these elements. The plaintiff was to receive a sum of money pursuant to the sale and transfer of a wine farm. The defendant was an incorporated firm of attorneys attending to the transfer of the farm to the new owner. The plaintiff needed assurance that he would be paid the money upon transfer of the farm. One of the defendant's directors provided the plaintiff with a written undertaking that stated, "On behalf of Mr. M. Scooney, we hereby undertake to pay to yourself the amount of 358,000 rand upon registration of the above property in the name of the purchaser." It later transpired that the particular director was instructed by his client not to pay the amount to the plaintiff because of possible claims that had to be set off against this amount. The plaintiff was therefore only paid a portion of the money stated in the undertaking. In an action for the balance, the plaintiff argued that in terms of the undertaking, the defendant was personally liable in contract to pay the outstanding amount to the plaintiff. The defendant's defense was that it merely acted on the instructions of its client and that no contract had arisen between it and the plaintiff. Expressly applying the reliance theory, the court upheld the plaintiff's claim and found as follows. I have already stated that, properly interpreted, the defendant's expressed intention appearing from the written undertaking was that the defendant would assume personal liability to pay the plaintiff the sum of 358,000 rand upon registration of transfer of Signal Hill Farm to the purchaser. By giving an undertaking in these words, the defendant, through its director Vandenberg, impliedly represented to the plaintiff that this was its true subjective intention. The plaintiff clearly relied upon this representation and arranged his affairs accordingly, inter alia by committing himself financially to another transaction. The plaintiff's evidence shows that in doing so the plaintiff was acting reasonably, that a reasonable person in the position of the plaintiff would also have relied upon the undertaking as establishing a personal liability on the part of the defendant, an incorporated firm of attorneys. This being so, the plaintiff has, in my view, established on a balance of probabilities that the defendant was, in its personal capacity, contractually obliged to pay the amount of 358,000 rand to the plaintiff upon registration of the transfer of Signal Hill Farm. By failing to do so, the defendant breached its contract vis-a-vis the plaintiff, and the plaintiff is accordingly entitled to the relief sought. Pause for reflection. Are fault and prejudice required to prove quasi-mutual assent? The similarities between the doctrines of quasi-mutual assent and Estoppel raise the question whether the reliance theory also requires fault and prejudice for successful application. At present, the position is not entirely clear, and the Supreme Court of Appeal has yet to provide clear guidelines in this regard. All indications seem to be that fault is not required because the reliance theory is often applied without mentioning it. Similar uncertainty exists in regard to whether prejudice is a required element, although in many instances where there will be fault on the part of the contract denier and prejudice on the part of the contract asserter. Generally, these are not regarded as strict requirements for the reliance theory. The correct approach seems to be that reliance must be reasonable in the light of all relevant considerations. End of the pause of reflection. The party who alleges a contract on the basis of quasi-mutual assent bears the onus of proving, on a balance of probabilities, the facts that warrant such a conclusion. Despite dissensus, the facts may indicate the existence of apparent agreement and of reasonable reliance on consensus, hence quasi-mutual assent. In this regard, the maxim "Savit subscriptor" is worth noting. It provides that someone who signs a document containing contractual terms is held bound because of the impression of agreement created by the signature. The doctrine of quasi-mutual assent has been seen as the basis of this rule, and the effect is to place an onus of rebuttal on the contract denier to show why a prima facie inference of reasonable reliance should not be regarded as conclusive. Then again, the facts may lean towards an absence of ostensible agreement and may also suggest a lack of reasonable belief in consensus, making the onus on the contract asserter far more difficult to discharge. 3.6. The objective approach as qualified by the Justa's error doctrine. The declaration theory, or wholly objective approach to contractual liability, grounds contractual liability purely on concurring objective declarations of will. The inner will or actual intention of the party is irrelevant. At the outset, however, it should be noted that even when finding subjective agreement, a court will have to look at the external manifestations of that agreement. The declaration theory may be distinguished on the basis that it overtly disregards actual intention in the creation of contractual obligations. This approach is highly controversial, and its mere mention seems to excite reaction from South African writers. One of the main points of contention is the theory's suggestion that a contract that neither party intended may be imposed on them, merely because the declarations indicate concurring intentions from an objective viewpoint. The need for a qualification of the declaration theory, which is the function of the Eustace era doctrine, as will appear below, there is an important feature of the objective approach. 3.6.1 The Declaration Theory in Case Law. The case for this objective approach in South African law is essentially twofold. In the first instance, there appears to be direct authority for it in the famous dictum of Wessels in South African Railways and Harbours versus National Bank of South Africa Limited. The law does not concern itself with the working of the minds of parties to a contract, but with the external manifestations of their minds. Even therefore, if from a philosophical standpoint the minds of the parties do not meet, yet if by their acts their minds seem to have met, the law will, where fraud is not alleged, look into their acts and assume that their minds did meet, and that they contracted in accordance with what the parties purport to accept as a record of their agreement. This is the only practical way in which courts of law can determine the terms of a contract. The general opinion in this regard seems to be that outright recognition of the declaration theory should not be read into the words of Wessels, and they should rather be regarded as indicative of the practical need to look for an actual intention in the declaration of the parties. At any rate, this dictum constitutes a hold sway even at the level of the Supreme Court of Appeal. The second more important indication of an objective approach in the South African law appears in a number of cases that strongly suggest, without directly subscribing to, an application of the declaration theory in tandem with the Eustace era doctrine. These cases do not reflect a strict application of the declaration theory, but rather an amended version or a generally objective approach. This is because absolute adherence to the declaration theory would mean that a person could never rely on a subjective mistake to avoid contractual liability. In terms of the Eustace era doctrine, however, an objective contract may be rendered void for a material and reasonable mistake. A prominent example of this generally objective approach to contract is National and Overseas Distributors Corporation Proprietary Limited versus Potato Board. The respondent invited tenders for the erection of a steel shed. The appellant submitted its tender which the respondent's manager on its behalf by way of a letter, which the respondent's manager accepted on its behalf by way of a letter. The appellant set out making arrangements for the erection of the shed. Thereafter, the appellant was informed by the respondent that the letter of acceptance had inadvertently been addressed to the appellant as a result of an administrative error, and that the respondent had in fact accepted the tender of another firm. The appellant refused to accept such an error, exonerated the respondent, and claimed that a contract had arisen between the parties, and that the respondent had breached it by denying its existence. In an action for damages by the appellant, the respondent disputed inter alia that a contract had arisen and that the manager had authority to enter into the contract on its behalf. The court a quo decided in favor of the respondent. The appellate division upheld that the appellant's appeal and stated, if the respondent had been a natural person who had accepted a tender according to its terms, there is no doubt that a contract would have been made when the acceptance was communicated to the tenderer, as by posting it. It would not be possible for such a natural person, if he repudiated, to escape liability by proving that he had posted the wrong letter or the like. That follows from the generally objective approach to the creation of contracts which our law follows. The court remarked that the respondent's plea made no mention of mistake and that there was no basis on which the mistake could be regarded as reasonable. It found furthermore that the contract was one that the respondent could lawfully enter into and its manager was the proper person to enter into contracts on its behalf. Therefore, as far as the outside world was concerned, the manager had bound the respondent when he sent the letter of acceptance, despite the fact that the board of the respondent had not passed a resolution authorizing him to send the letter. This case has been criticized as being based on the application of a Stark type of declaration theory, and indeed it lends itself towards such an interpretation. However, the decision has been most influential, and to this day the above quoted dictum is cited with approval by the Supreme Court of Appeal. A generally objective approach to contract formation has also been suggested in several other cases, and writers too have acknowledged that case law does sometimes reflect such an approach. 3.6.2 The Eustace Error Doctrine. It seems that the Eustace Error approach to the problem of mistake in contract find its origin in a text dealing with restitutio in integrum, on the grounds of reasonable error. Whether this text applied to the issue of mistake in contract is open to doubt, but the courts used it as such from the late 19th century, and the doctrine is now firmly entrenched in positive law. Generally speaking, the Eustace Error approach, like Estoppel, is not in itself a theory of contractual liability. However, it functions as a corrective measure in the case of dissensus and provides that a party will not be held bound to an agreement if that party, apparently but mistakenly, gave his or her consent, and if his or her mistake is material and reasonable. Once the contract assertor has shown that there is an ostensible agreement, that is, consent from an objective viewpoint, or rather that there is a common intention expressed, the contract denier bears the onus of proving that his or her mistake is both material and reasonable, in order to be absolved from liability in terms of the apparent contract. If the contract denier succeeds, the contract is void ab initio. But if he or she fails, the contract denier will be contractually bound on the terms originally proved by the contract assertor. The issue of materiality within the context of mistake has already been dealt with, but the factors or circumstances that make a mistake reasonable remain to be considered. Generally speaking, an operative mistake will be seen as excusable or reasonable or Eustace, according to objective circumstances. However, the Eustace Error doctrine has never been comprehensively formulated, and guidelines as to what may be regarded as a reasonable mistake have developed piecemeal in case law. To begin with, there are two dicta that are virtually synonymous with the Eustace Error approach. Firstly, there are the words of Chief Justice Fagan in George versus Fairmead Proprietary Limited. When can an error be said to be justice for the purpose of entitling a man to repudiate his apparent assent to a contractual term? As I read the decisions, our courts, in applying the tests, have taken into account the fact that there is another party involved and have considered his position. They have, in effect, said, has the first party, the one who is trying to resolve, been to blame in the sense that by his conduct he has led the other party as a reasonable man to believe that he was binding himself. If his mistake is due to a misrepresentation, whether innocent or fraudulent, by the other party, then of course it is the second party who is to blame, and the first party is not bound. The second dictum is that of Schreiner in National and Overseas Distributors Corporation Proprietary Limited versus the Potato Board. Our law allows a party to set up his own mistake in certain circumstances in order to escape liability under a contract into which he has entered. But where the other party has not made any misrepresentation and has not appreciated at the time of acceptance that his offer was being accepted under a misapprehension, the scope of a defense of unilateral mistake is very narrow, if it exists at all. At least the mistake or error would have to be reasonable, justice, and it would have to be pleaded. These and other cases reveal certain interrelated criteria for ascertaining the reasonableness of an operative mistake. These are set out below. First, a material mistake will usually be reasonable if caused by a misrepresentation on the part of the contract asserter, or someone for whose acts he or she may be legally liable. For a representation to render a mistake reasonable, it must be acceptable in the eyes of the law. In this regard, it is sometimes said that the representation must be wrongful or contra bonos mores. A misrepresentation could either be positive or negative. A material mistake induced by a positive misrepresentation, that is, where one party has stated something that is false, is almost invariably regarded as Justa. For instance, in Allen versus 16 Sterling Investments Proprietary Limited, the plaintiff's error as to the property he was purchasing was caused by the misrepresentation of the defendant's agent. The agent misled the plaintiff by pointing out to him a different property to that stipulated in the deed of sale that the plaintiff signed. The court found that the plaintiff's mistake had been reasonable because it was caused by the misrepresentation of the defendant's agent in pointing out the wrong property. A negative misrepresentation occurs where a party has kept quiet in circumstances where in law he ought to have spoken out, for example, to correct the misunderstanding of the other party. Silence can constitute a misrepresentation, that is by omission, but only when it is wrongful in the eyes of the law. That is, when there is a legal duty to speak in certain circumstances. A legal duty to speak has been found to exist in the following instances. First, where the contract assertor knows or ought to know as a reasonable person that the other party is mistaken. He or she must correct the contract denier's wrong impression. For instance, in the English case of Hartog versus Collin and Shields, the defendants offered the plaintiffs 30,000 skins at prices per pound when they meant to offer to sell at prices per piece. The plaintiffs accepted the offer while knowing that the defendants had made a mistake and that the prices offered were much lower than the prices the defendants intended to offer. When the defendants realized their mistake, they refused to perform in terms of the contract. The court refused the plaintiff's claim for breach of contract. The plaintiffs were not entitled to snatch at a bargain that they knew was not intended by the defendants. Similarly, in Prince versus Absa Bank Limited, the appellant mistakenly believed that the document he signed was a limited rather than an unlimited suretyship. In other words, that his potential liability was limited to 10,000 rand, whereas in fact on the wording of the document it was unlimited in extent. The respondent bank sued the appellant for an amount far in excess of 10,000 rand, and the appellant refused to pay. The court quo granted judgment in favor of the respondent. On appeal, the court found that even the respondent's bank's own correspondence supported the appellant's contentions. The bank ought therefore to have been aware of the misapprehension on the appellant's part. Its failure to remove the misunderstanding rendered his mistake useless. Secondly, where prior to the conclusion of the agreement, the contract assertor created an impression directly conflicting with the provisions of the agreement that he or she alleges to be the contract, he or she must draw the contract denier's attention to the discrepancy. A classic case in this regard is Detroit versus Atkins Motors BPK. The respondent advertised a Mercedes-Benz 350 1979 for sale. The appellant, having seen the advertisement, orally agreed with the respondent to purchase the car. Later, at the respondent's request, the appellant signed a document without reading it. The document, inter alia, contained a clause exempting the respondent from liability for any misrepresentation regarding the year of manufacture of the car. The respondent did not draw the appellant's attention to this clause. When the appellant later discovered that the car was in fact a 1976 model, he sued for cancellation of the contract and restitution. The trial court found that the appellant was bound to the document, including the exemption clause, because of his own negligence in not reading the document, and dismissed his claim. On appeal, the appellate division thought otherwise and held that the purpose of the advertisement had been to create the impression that the vehicle had a specific attribute and to elicit offers. On the strength of this impression, of which the respondent was aware, the appellant purchased the car. By not saying anything about the exemption clause, the respondent created the impression that the document did not contradict the advertisement. The respondent therefore misled the appellant by way of omission, and this rendered his mistake regarding the contents of the contract reasonable. These two instances are related in that the second approach seems to be specific application of the first. It should be noted that the Supreme Court of Appeal has held that where a contractual term, such as an exclusionary clause, may reasonably be expected to be part of the contract, a duty to speak on the part of the contract asserter does not automatically arise. Of course, this should not be regarded as an absolute rule, and much will depend on the nature of the contract in question and the relevant circumstances. For instance, in Brink v. Humphreys and Jewell Proprietary Limited, the court found that a personal suretyship hidden in a credit application form, which the appellant unwittingly signed, was a trap for the unwary, and that the appellant was justifiably misled by it. Secondly, if the contract denier is not to blame for his or her mistake, in that he or she behaved as a reasonable person in the circumstances would have done, and acted without negligence, there is some authority to the effect that the mistake is excusable. Nevertheless, as in the case of the doctrine of quasi-mutual assent, the question of fault within this context is fairly contentious. There is authority for the notion that fault plays a definite role in regard to the Justa's error approach, but strong reservations in this regard have been expressed at the highest level. However, it seems to be clear that if there was fault on the part of the contract denier, it will weigh against a finding of excusability on his or her part, although it will not necessarily be conclusive, especially where the contract denier can prove a wrongful misrepresentation on the part of the contract asserter. There are many examples in the case law of instances where the contract denier has been negligent in not reading a contractual document, but nevertheless was found not to be bound on the basis of justifiable mistake. Third, if the contract denier did not cause a reasonable belief in the contract asserter that the contract denier had assented to the agreement, an error is Justa's. In other words, the error is Justa's when the contract asserter's reliance on the appearance of consensus is unreasonable, or where there was no real reliance at all. Number 3.7. Reconciliation of the subjective and objective approaches. The application of both qualified subjective and objective approaches in the case law to the issue of material mistake gives rise to several contentious issues. These approaches seem to be polar opposites, which raises the question whether the approach to contractual liability in South African law is essentially subjective or objective. Moreover, several commentators have considered the declaration theory undeserving of support in any form, and viewed its association with the Justa's error doctrine as equally unacceptable. For these and other reasons, some writers consider it prudent to throw out the usus error doctrine altogether in favor of the direct reliance theory as a corrective to the will theory. Then again, others considered the usus error approach to be practical and feasible way of dealing with material mistake where there is ostensible agreement. A further observation was that if there was to be reconciliation between the doctrines of quasi-mutual assent and Eustace error, the latter had to be defined in terms of the former. In effect, the Eustace error approach would amount to an indirect application of the reliance theory. As will be seen, it is this last option that the courts have chosen. 3.7.1 Sonop Petroleum South Africa SA Proprietary Limited versus Papadogianus. Only fairly recently in Sonop Petroleum SA Proprietary Limited versus Papadogianus did the appellate division provide much needed direction. In that case, the parties entered into a 20-year lease agreement. However, when the appellant's attorney drafted an addendum to the lease, he mistakenly shortened the lease period from 20 to 15 years. The respondent, as owner of the property, stood to gain from a shortened lease period and signed the addendum without a murmur, later claiming that he believed that the appellant had intended to shorten the lease period. The appellant had no such intention and claimed inter alia that the addendum was void in light of the mistake. The court a quo found in favor of the respondent on the issue of mistake. It held that the appellant's mistake had not been Eustace because it was due to its own fault. On appeal, Harms, as he then was, categorized the appellant's mistake as unilateral on the basis that only the appellant mistakenly believed that its declared intention conformed to its actual intention. He then proceeded to review the law pertaining to mistake in contract. He confirmed that, as a general rule, the law concerns itself with the external manifestations and not the workings of the minds of the parties to a contract. However, in the case of alleged dissensus, the law has regard to other considerations. In such cases, he continued, resort must be had to the reliance theory in order to determine whether a contract has come into being. From reliance, he turned his attention to the issue of Eustace error and cited the classic statements of this approach from George versus Fairmead Proprietary Limited and National and Overseas Distributors Corporation Proprietary Limited versus Potato Board. He suggested that what the judges in those instances had done was to adapt the well-known dictum of Blackburn in Smith versus Hughes for the purposes of the fact in their respective cases. In effect, Harms was saying that the Eustace error approach was an adaptation of the reliance theory. In my view, therefore, the decisive question in a case like the present is this: did the party whose actual intention did not conform to the common intention expressed lead the other party as a reasonable man to believe that his declared intention represented his actual intention? To answer this question, a threefold inquiry is usually necessary. Namely, firstly, there was a misrepresentation as to one party's intention. Secondly, who made that representation? And lastly, or thirdly, was the other party misled thereby? The last question postulates two possibilities. Was he actually misled, and would a reasonable man have been misled? To this he added the following. In the present case, the appellant represented to the respondent that its intention was to reduce the period of the lease. One has then to determine whether the misrepresentation had any effect, that is, whether the respondent was misled thereby. If he realized, or should have realized as a reasonable man, that there was a real possibility of a mistake in the offer, he would have had a duty to speak and to inquire whether the expressed offer was the intended offer. Only thereafter could he accept. The snapping up of a bargain in the knowledge of such a possibility would not be bona fide. Whether there is a duty to speak will obviously depend on the facts of each case. Harms found that the respondent was aware of the responsibility of a mistake on the part of the appellant, and had a duty to speak and inquire whether the latter actually did intend to shorten the period of the lease. The respondent failed to discharge his duty, with the result that there was no consent, actual or imputed, and the addendum was declared void to the extent that it purported to reduce the lease from 20 to 15 years. The Sonab test, or the reliance test, this inquires whether in instances of dissensus the contract denier misled the contract enforcer into a reasonable belief that the contract denier had actually assented to the contractual terms in question. If the contract enforcer realized, or should, as a reasonable person, have realized that there was a real possibility of mistake on the part of the contract denier. The contract enforcer had a duty to speak and to inquire whether the contract denier's expressed intention conformed his or her actual intention. Failure to do so results in an absence of reasonable belief in consensus on the part of the contract enforcer, and conversely indicates a reasonable mistake on the part of the contract denier. This reliance test may be simplified as illustrated in the following example. A misrepresents his contractual intention, usually by signing a document that states something different from his actual intention. B relies on this misrepresentation in the sense that she genuinely believes that A has agreed to the terms reflected in the document. B's belief in the existence of consensus is reasonable in the circumstances resulting in a reliance-based contract. If the objective circumstances that render B's belief reasonable are the very same ones that render A's mistake injustus, we have a complete reconciliation of the doctrines of quasi-mutual assent and Justa's error. Harms's formulation has had a remarkable impact on case law and justifiably may be regarded as the authoritative statement of principle on the reliance test. In the process, he affirmed the principle in Smith v. Hughes as providing the basis for the doctrine of quasi-mutual assent or direct reliance theory in the South African law of contract. In effect, then, the reliance theory is the primary approach to be adopted when dealing with dissensus. The Eustace error approach is just an application of the reliance theory, and more specifically, an indirect application. Nevertheless, the courts have continued to apply the Eustace error doctrine, and in most cases, a mistaken party may choose to plead his or her case in terms of either direct or indirect reliance. Harms considered that fault was unnecessary for an application of his test, and that Estoppel merely bedevils the inquiry, and that reliance thereon is not conducive to clear thinking. No mention was made of prejudice in the circumstances. The obiter dictum regarding estoppel should, however, not be interpreted to mean that estoppel can never be invoked within the context of material mistake. 3.7.2 Direct or indirect reliance. The continued application of the Eustace error doctrine in the South African law of contract raises some interesting questions. One is whether an objective approach to contract as corrected by this doctrine still applies. Some writers suggest that the declaration theory has already been laid to rest, while others are of the view that case law endorsing an objective approach should be expressly overruled by the Supreme Court of Appeal. The fact is that the courts still make decisions that could be interpreted as an application of a generally objective approach, usually coupled with the Eustace error doctrine. It is suggested, therefore, that even such decisions should not be regarded as problematic from the conceptual viewpoint. The reliance theory and the Eustace error approach are mirror images of one another and, in most instances, of mistake. Either may be applied with the same result. Consider the decision in National and Overseas Distributors Corporation Proprietary Limited versus Potato Board, which is usually considered to be indicative of an objective approach or even the declaration theory. In this case, the respondent mistakenly accepted the offer of the appellant when it actually intended to accept the offer of another party. The court accepted that a contract had arisen purely on the basis of the concurring expressions of intention of the parties, that is, the declaration theory. It also indicated that if the respondent had pleaded Justa's error, its mistake would not have been regarded as reasonable. However, this case can be rationalized just as well in terms of the doctrine of quasi-mutual assent. The respondent, by accepting the appellant's tender, clearly led the appellant to believe, and the belief was reasonable, that consensus had been reached and therefore a contract had arisen between them. The factors that indicated an absence of reasonable mistake on the part of respondent, the contract denier, conversely implied the existence of reasonable reliance on the part of the appellant, the contract asserter. Seen from this perspective, many such cases do not pose insurmountable conceptual difficulties for those opposed to the declaration theory. Pause for reflection. Limitations and benefits of the Justa's error approach. In many instances, either direct or indirect reliance will suffice. However, to the Justa's error doctrine cannot be applied in instances where there is no objective appearance of agreement. A typical example of an ostensible contract is one where the contract enforcer can produce a document embodying contractual terms that the contract denier has apparently assented to by signature. In cases where there does not seem to be a prima facie consensual contract, the contract enforcer will have to prove that one may be deduced from the existing evidence. More often than not, he or she will attempt to prove contractual liability on the basis of reasonable reliance on consensus. Furthermore, in cases of dissensus where there is evidence of an ostensible agreement between the parties, the Justa's error doctrine has a practical advantage. It shifts the focus from whether there is a basis for contractual liability, because prima facie a basis already exists, to whether, despite the appearance of agreement, there are objective factors that nevertheless indicate that the contract denier should not be held bound to the ostensible contract. In doing so, it observes the need to preserve security and certainty in market relations, while also providing a vehicle with which to infuse considerations of fairness into cases involving dissensus. End. The reliance theory as the overarching principle may be preferred in its direct form in many instances. Although the Justa's error doctrine may work equally well, there is, however, at least one instance where both direct and indirect reliance may be applied, but the direct reliance theory perhaps is the preferable option, and that is where the contract denier's mistake is caused by the misrepresentation of an independent third party. In some instances, the courts have been prepared to absolve a party from contractual liability on the basis of reasonable error. But in Slipknot Investments 777 Proprietary Limited versus Dutoy, the Supreme Court of Appeal appropriately stated that the decisive question in such cases was whether the party whose actual intention did not conform to the common intention expressed led the other party as a reasonable man to believe that this declared intention represented his actual intention. In applying this, the court found that the contract denier was bound by a suretyship clause contained in a contractual document, despite having labored under a mistake caused by the fraud or misrepresentation of a third party. Because by signing the document he had led the contract asserter reasonably to believe that his expressed intention to be bound by the contract accorded with his actual intention. As stated at the outset of this chapter, it is fair to say that the general consensus of opinion seems to be that actual agreement is regarded as the primary basis of contractual liability in South African law. However, there is also evidence of a generally objective approach in case law. At any rate, in vast majority of instances, the parties are in agreement, at least as to the material aspects of their contract. In exceptional cases where the parties are not ad idem due to operative mistake, secondary, reliance-based principles are applied either directly, the doctrine of quasi-mutual assent, or indirectly, the Justa's error doctrine, to determine the existence or absence of contractual liability. Although not all wrinkles regarding the allocation of contractual responsibility in instances of dissensus have been ironed out, and the reliance theory and Justa's error approach still require fine-tuning to make provision for so-called hard cases, the position at present is generally sound from both a theoretical and practical perspective. In the figure below, assume A and B have both signed a written agreement, and that A alleges the contract is void for mistake, while B asserts that it is valid and binding. Okay, then there is just a small diagram that you can study on your own time, figure 3.3. Number 3.8, common mistake. A common mistake differs fundamentally from unilateral or mutual mistake, in that it does not lead to dissensus. It nonetheless results in a contract being void. Therefore, common error is not a true case of mistake, and the principles discussed above do not apply. In such instances, both parties to a contract make the same mistake, with the important proviso that the mistake does not relate to the intention of either party. In fact, the parties are in complete agreement, consensus ad idem, and each knows the intention of the other and accepts it. However, both are mistaken about some underlying fundamental fact, in that they have a mistaken assumption about a present or past fact. Common error results in the contract being void. For example, in Dickinson Motors Proprietary Limited versus Oberholzer, the plaintiff's son purchased 2 Plymouth motor cars on hire purchase from 2 different parties. Car A from the defendant and car B from a third party. After exchanging car B for his father's Hudson motor car, the son disappeared, leaving unpaid amounts on both vehicles. The defendant obtained judgment against the son in respect of car A, and then had the car in the plaintiff's, the father's possession, attached to satisfy the debt under the mistaken impression that it was car A, whereas it was in fact car B. The plaintiff, while under the same mistaken belief that the car was in his possession was car A, paid the outstanding debt to the defendant to retain possession of the vehicle. Shortly thereafter, the same car was attached, but this time legally at the instance of the third party who had sold the vehicle to the son. The plaintiff claimed the return of the amount that he had paid to the defendant. He succeeded, and the appellate division held that the contract between him and the defendant was void because their contract was based on a common mistake. There are several views as to why common mistake renders the contract void. Probably the most accepted explanation is the implied term theory, which in general holds that the particular circumstances may justify the inference that the parties implicitly, tacitly agreed to make the existence of their contract dependent on the truth of a material fact, or rather a supposition. A supposition or assumption occurs where the parties render their contract dependent on the presence or absence of some fact or of the past or present. If the fact is present, there is a binding and enforceable contract. If not, there is no binding contract, and the parties may reclaim whatever they have performed. That is restitution. Pause for reflection. A common error must relate to a term of the contract. It is important to note that for common error to have an effect on a contract, the parties must have elevated their assumption to being a term of the contract by agreeing, expressly or tacitly, that the existence of the contract depended upon the correctness of the assumption. If a common error does not relate to a term of a contract, it will usually amount to little more than an error in motive, albeit a common error in motive. It will then have no bearing on the validity of the contract. In Dickinson Motors Proprietary Limited versus Oberholzer, the contract held that the common mistake must have been vital to the transaction, in the sense that neither party would have agreed to the contract if they had known the true situation. Presumably, if the common mistake is fundamental in such a manner, the supposition would qualify as a tacit term. Number 3.9 Rectification. Where parties reduce their contract to writing, it is possible that the written instrument unintentionally fails to reflect their common intention accurately. In these cases, the parties are in full agreement and there can be no talk of actual mistake or dissensus. Usually, the parties will rectify the document themselves or even simply perform in accordance with their common intention. However, if the parties cannot agree on amending the written instrument and the one party insists on a strict enforcement of the contract as written, the other party may apply to court for rectification or correction of the written document so that it properly reflects the actual common intention of the parties. However, what is rectified is not the contract itself as a juristic act, but is rather merely the document in question, because it does not reflect what the parties intended to be the content of their juristic act. Rectification is generally regarded as a consequence of the primarily subjective approach of South African law to contractual liability. Therefore, a party to an incorrectly recorded agreement is permitted to rely on the contractual terms actually agreed upon and to have the document corrected to conform the true intention of the parties. Rectification may also be permitted where the disparity between the preceding agreement and the subsequent written document is caused, not by bona fide mutual mistake, but by the dolus fraud of one of the parties. In general, the courts require that a party claiming rectification must establish that the document does not reflect the common intention of the parties. The party claiming rectification should also establish what the true intention of the parties was and how the document is to be amended to reflect that intention. Determining the true intention of the parties is a question of fact. Proof of a prior agreement, which in itself need not constitute a contract, is regarded as sufficient. Nevertheless, the courts have shown themselves to be most flexible in allowing claims for rectification. For instance, in Moulton v. Honeycomb, rectification was granted even though the parties had purposefully refrained from reducing the whole of the agreement to writing. There was thus no mistake as to what should have been recorded in the document. Then again, in Milner Street Properties Proprietary Limited versus Ackstein Properties Proprietary Limited, the parties' agreement was correctly recorded, but they were mistaken in assuming that the transaction as recorded qualified for a 0 rating as regards value added tax. The court permitted rectification of the document in order for it to comply with the statutory amendment, of which the parties had been unaware and which would enable the contract to qualify for such an exemption. It seems then that the courts are prepared to grant rectification to prevent unintended harsh consequences resulting from the manner in which the parties' agreement is recorded. However, where writing is a constitutive requirement for the very existence of a contract, the courts do not permit rectification of a document that purports to constitute such a contract but which, on the face of it, does not comply with the prescribed formalities. In such cases, there is no distinction between the document and the juristic act involved. Conversely, where on the face of it, the document does comply with prescribed formalities, rectification is possible.